Welcome to the first podcast from Yale Insights. We're a company that uses technology to develop emotional intelligence for remotely delivered focus groups. Today we'll be talking to our first guest, Nick Panagakis. He's a partner and attorney at the Morgan & Morgan law firm. We'll be talking to him about how he uses Yale Insights to drive success for his firm, but also the types of technology challenges he's faced in practicing law during the COVID-19 pandemic, and hopefully learn a little bit more about him and his career as well. So let's get started. All right, Nick, thanks for joining us for our first podcast for Yale Insights. We really appreciate your time.
My pleasure. Thanks for inviting me.
As I said in the intro, you're an attorney at Morgan & Morgan, but can you tell us a little bit more about the area of practice that you focus in, and maybe a little bit more about Morgan & Morgan? It's a national law firm, but maybe some of our audience won't know who they are.
Yeah, so our founder, John Morgan, started Morgan & Morgan a little over 30 years ago right here in Orlando. So we call the Orlando office, where I've practiced exclusively, the mothership. And so, I've been here, this is my 13th year here at the firm, going on almost 14. And I do exclusively personal injury, have kind of a sort of a boutique practice within the firm, and we have a team that does solely catastrophic injury and death cases here within the firm.
Okay.
And we operate our group, which is comprised of 5 attorneys, as a again, kind of a boutique practice within the firm, working on the cases collectively. And so that way it allows us to have the resources to take on, anybody that may go against us by way of attorneys. And we've got a great litigation support team. So we do that throughout Central Florida. Morgan & Morgan, for those that don't know, although I think most people do, that at least do personal injury type of work. We're all throughout the Southeast. We have offices all throughout Florida. We've expanded also into Texas, California as well. I think John Morgan says we're the largest personal injury law firm in the world. I don't know how much personal injury exists outside of the U.S., but definitely within the U.S. And there's a very heavy emphasis, which is what brought me to Yale Insights, in trying cases.
So you were talking about the way that you handle the personal injury division as a group, and that you've got attorneys that you can assign based on whoever you happen to be facing on the other side of a case. What does your role look like there? Are you trying cases personally, or are you more of a management level at this point, or?
No, I mean, the goal of our team, and we started this, Scott, literally January 1, or I guess technically January 2nd was the first calendar day, I believe, of 2020. And then COVID, as you know, hit 2 months later. So the goal was to try these cases as a team, work them up collectively. And obviously COVID hit. I think the last trial, and some trials have just now started here in Florida, but the last trial that we did pre-COVID, I want to say, was the end of the second week of March. And so that sort of stopped everything. So, we haven't been able to take it to full fruition, but no, I'm a trial attorney. I've averaged about, anywhere between 3 to 4 trials a year since I've been here. And then I did it on the other side before I came here, had about the same amount of trials on the other side. I like this side a lot better for a lot of reasons. No, I am a trial attorney. And again, I think, as we were discussing, we've been doing focus groups for a number of years, and that sort of brought us to Yale Insights, and we can sort of discuss how I found out about it, or and why I think it's so unique.
Yeah, well, since you bring it up, that's a good question. Let me ask you first, what kind of argument preparation did you do before you found out about Yale Insights? Did you guys conduct your own live focus groups, or were you going more based on experience, or how were you handling that before?
So I will tell you, Scott, it's kind of been all the above. When we first started doing focus groups, we have a senior trial lawyer here, Keith Mitnick, who's sort of nationally known and tries cases throughout the U.S. for our firm, and he's published as well. So Keith, along with me initially, we started mock trying cases, kind of the traditional old school mock trial. So we actually have a courtroom here in Morgan & Morgan.
Oh, wow.
15th floor. We have a mock courtroom. We have a judge's bench. We have a jury box. We have a gallery, and then we have the lawyer tables. So we started this out probably at least 10 plus years ago now, doing the traditional mock trial, where there would be, if it was your case, you'd be the plaintiff's trial attorney and you do your argument, have exhibits, and then you would have someone like Keith or someone else do the defense side. And we would bring people in from Craigslist and, feed them. We'd have like a morning and an afternoon group. We have cameras there and we'd film them. And we give them, mock jury instructions, and then we give them a mock verdict form, and they give us a verdict. The problem we found with that, Scott, is that we're being advocates, okay? And it's very hard when you are a professional advocate not to be an advocate.
Yeah.
And so we were oftentimes getting a picture that really wasn't accurate. Because we were advocating, and maybe the defense attorney on the other side maybe wasn't advocating maybe as well as they should have. So it really wasn't an accurate picture. We were happy a lot of times with the results, but that wasn't really an accurate assessment of what a jury was going to do. And so we did that for a while. And then, what I've been doing, and I think there's still a place for it. And, I can talk about what makes Yale Insights so unique and game-changing, either by itself or in addition to the traditional focus group. But, we started doing both our own sort of focus groups very informally with Craigslist, where, we might show them some videos and then leave, again, film them. Or we might show them some exhibits, without advocating. And then we've even done the traditional professional focus group, where you have, some really, really experienced either attorneys or jury consultants or a combination of the two. Some of these folks are published, and, they would do professional focus groups 2 a day. Very expensive, sometimes, upwards of $20,000. And there's still a place for that. But, you've got to have the kind of case that can justify that kind of time and expense. And so, I know it's sort of a long rambling answer, but to answer your question, it was kind of all the above, leading up to now.
And it sounds like, especially I can imagine with putting a mock trial situation together, but even probably, even probably with just setting up a focus group in your office with people from Craigslist, that, that takes a lot of time up in your office and probably a lot of human resource just to get it coordinated and have somebody, setting all of that stuff up and then spending the time on it, right?
Well, I've been blessed to have a great team. My paralegal, Megan Watts, is taking the lead on this.
We're hoping to speak to her in the future as well.
Yeah, and she has a real passion for this. I tell people all the time, teamwork makes the dream work, Scott, and I believe it in my core.
Amen, yeah.
You can't do this without a great team that has passion. But it is very time consuming, but at the same time, it is so important, because one of the things that we as lawyers think is we think we know everything. And guess what? We don't know that much. If you're being honest, we just don't know that much. And we miss things. You fall in love with your case. You're an advocate. Sometimes you can't see the forest through the trees. Sometimes you miss the most basic arguments. I will tell you, and I can give you an example if you want, but
Yeah, absolutely. Go for it. Yeah.
Yeah. Okay. All right. So, the first memory that sort of sticks out in my mind, Scott, about the just critical benefit of focus groups and how lawyers sometimes oftentimes, to be fair, sort of miss the forest for the trees. Is I had a case that ultimately went to trial, and when we did this back when we were still doing mock trials, and we had two groups. We had a morning group and an afternoon group. And the facts of the case, I'll briefly tell you. My client was a serious cyclist, professional engineer, not the crazy Jimmy John's kind of, cyclist that we see that we all kind of cringe about.
Yeah.
He was doing his regular, middle of the day training run. And he noticed a woman who turned out to be our defendant in a smaller SUV, and she was distracted. She was turned out she had her 5-year-old daughter in the back seat, and she had her right turn signal on, but she's, was going into the bike lane, and he could tell that she could not see him. Now, he was in the bike lane parallel to an elevated sidewalk. And so he had to make a split-second decision. In that split second, he decided to actually go into traffic around her so he could then cut in front of her and then get back into the bike lane. And guess what, Scott? He would have made it, but at the last instant, she finally saw him, panicked, and these are her words, not mine, and hit her brakes, and he went into the SUV with his shoulder, severely broke his acromion, which is a part of your shoulder that's really the strongest, hardest bone in your shoulder. I mean, it takes a massive amount of force to break.
Ouch.
But here's the point. When we did the focus group, the first one, and none of us saw this. The defense was not arguing this at all. The first jury placed almost all the fault on him, simply because they thought that he should have laid the bicycle down like a motorcycle. One of the things that I learned, and as you can probably tell, I don't do a lot of cycling, okay? But one of the things that I learned is that a bicycle with those thin little bicycle tires is not like a motorcycle. You can't lay it down. If you lay it down, the tires will burst. You will then go flying onto that elevated sidewalk, and there was actually a power pole and a fence. He would have impaled himself had he done that.
Yeah.
So now here's the thing, though, Scott. We did not know this because the defense never brought it up, and no one ever thought it was an issue. They even had an expert. No one brought it up. It was a non-issue. It was a non-starter, except to the people that mattered, otherwise known as the jury. So when we did the second focus group, same case later on the same day, was the afternoon group, we took the pictures of the scene, and all we did is we blew them up and addressed that argument and why that wasn't feasible. And this case went from a case where initially my client was cited for being at fault in the crash report from the police, that ticket was thrown out, to then a focus group where they put almost all the fault on him and the insurance company was blaming all the fault, to then a second focus group just changing and addressing an issue that we thought was a non-issue, to putting almost no fault, to then a jury verdict that put 100% of the fault on the defendant. All of that, Scott, I'm convinced, had we not addressed that in a focus group, we would have gotten a very unfavorable verdict, and we would have never known why until after the trial, assuming the jury told us, then, as is their right or right not to.
Yeah, and that's I imagine you'd have to be right about that, because it obviously changed the way you presented the arguments then when you actually did go to trial.
Absolutely. But again, that is the critical reason why you do a focus group. I mean, there's a saying, don't guess, test. I mean, it's just a fact. I mean, you cannot guess at these things, and you can't assume as an attorney who falls in love with your case and that you know every issue, or that every issue you think is important is even important, or even as favorable or favorable at all for you as you may believe.
Yeah, that's a good point. Now, my brother's actually an attorney as well, and he's brought this up before, or just mentioned it, when he talks about his work. That, and you tell me if this is something that you've experienced. Have you ever been in a trial where you didn't do a focus group, you didn't have that kind of preparation for your argument, and during the trial, it really seemed to you like the jury was responding to your arguments, and you felt like you had them, and then you were just completely shocked when the verdict came back the other way?
Yes. Unfortunately, yes. And first thing, my apologies about having a brother that's an attorney. So hopefully you're still recovering. But yeah, and unfortunately, Scott, one thing that I have learned, I'm in my 24th year of practicing law, is having jurors that smile at you and nod at you is not an indicator that they like you or are agreeing with your arguments. Some people just do it to be polite. Some people just do it as a nervous tick. And so to assume that you know by their reaction how they're going to do or how they're going to address an issue that you haven't tested is really fool's work. And I mean, one of the things that we even do as well, by way of, it's not really a focus group, but and this is probably pretty well known, is we do pretty extensive research of the potential jury panel prior to trial, during trial, as we're picking them, and even after. Because the judges tell them they're not supposed to get on social media, but I can't tell you the amount of times that people take an oath and they violate that oath.
Yeah.
And so, I hate to say it, you almost have to be like the hall monitor, so to speak, but you can't assume that people are going to follow the rules. And this is not, we talk about mock trial, and that's just pretend. I mean, this is for real. I mean, this is somebody's life, and the stakes are just too high. And it's if it's done right, it's a verdict for all time, and it matters.
Well, so you've talked about using traditional focus groups and mock trials, and that we sort of started talking about that because you guys have now started using Yale Insights emotional intelligence remotely delivered focus group products. So how was that process different for you?
Well, number one, it's COVID proof. Okay, so
Yeah.
it survives any global pandemic known to mankind. Number one,
Uh-huh.
and I mean that sincerely. I mean, I think we are a society right now where we are going to, even though I still believe in looking at the whites of someone's eyes, I mean, it is something that is with us forever, and I think in a positive. I think we've learned that we can do a lot more remotely, including me, who was resistant to that, as a permanent and positive change. But the other thing, going back to what you discussed before, it's very cost effective. It's very time effective, and it is quick and it's easy. And I told Aaron Itkowitz, I said, it made me think of the very famous book of Blink from Malcolm Gladwell that we all know. I mean, Malcolm Gladwell is a brilliant writer. He's got his own podcast. If you haven't heard, it's great. It's called Revisionist History.
Mm-hmm. Yeah.
Book Blink, the premise of it is that we make a decision in our subconscious mind in as quick as we blink, and we don't even realize that we're doing it.
Right.
And that Yale Insights is measuring. In this context for attorneys, I think it is a game changer. And I think, as I told you a few minutes ago, I think it is critical in and of itself, and or as a complement to the traditional focus group. But I think it is a product. In fact, I know it is a product that is so unique in its efficiency, in its cost, and then finally in the feedback that you get. And we can discuss that some more. But the feedback, and I'm not just talking about the reporting that you get, but I'm also talking about the professional breakdown that you get from Yale Insights and their extensive team, breaking down the data and explaining the data to you in all different areas.
I imagine that as you guys start to adopt this service, more, you'll probably find more ways you can use it too. I'm sort of wondering, is there a possible application for this even when it comes to like jury selection processes at all?
Well,
I mean, what do you think?
I mean, I think the answer is potentially yes. I mean, I will tell you, going even before that, in the pretrial stage, the vast majority of these cases, I mean, statistically, somewhere between 95 to 98% of cases are not going to go to trial. So you're preparing these cases to put them in a posture to resolve. And the majority of cases are going to resolve at that mediation stage, somewhere between 2/3 to 80%, depending on, which statistics, might be most accurate. But that was kind of the light bulb that went off in my head, in that this would be a really great tool to show the other side, we made all your arguments. We made all of our arguments. These people don't know who any of us are. And then we asked them who's at fault and what is this case worth? And this is what we said. And because of that, we believe that you are totally at fault and the value of this case is X. And here's why.
Right. So you're not even at that point. Yes, of course, it could help you avoid more trials potentially, but then also, could potentially lead to higher settlement offers for your clients as well.
Well, or Scott, again, just to be brutally honest, again, as I'll always try to be,
sure.
If you get a result that you don't like, you kind of need to know that going into mediation.
Yeah.
We fall in love with our case, but if we think our case is worth $1 million and the focus group is telling us that the value is $500,000, we can ask for $1 million, but we need to be going in there with a clear mind and obviously giving the support to our client. This is why it's a $500,000 case. This is what we've done. Now,
and then have reasonable expectations that way. Yeah.
Absolutely. And it's confidential, but you've got to give your client a basis for it. Again, it can't just be, I say so.
Right. And having deep level, both qualitative and quantitative analysis available is got to be a very useful tool.
But I mean, going back to your original question, Scott, the great thing about the data that you were mentioning is it's going to tell you and give you that heads up, who is your ideal type of juror for your kind of case. And the reason we know that is this, both qualitative and quantitative data that we have is telling you how people emotionally react. Trials are, as much as we say they're about logic, it really is. And even though the courts don't want it to be about emotion, it is a battle of emotion. People are emotional. They're human beings, whether it makes them either emotional or non-emotional. Those are the types of jurors that you want to target. And that's, going back to your original question, that's the kind of information you want to know as you're picking a jury, because we are allowed, with limitations depending on your jurisdiction, to select and deselect certain jurors, and sometimes strike people. Obviously, we have a cap, just because we think someone may be more favorable.
If I wonder if there's even a way that it might be able to, if you crafted the right kind of video to show an audience, if it might help guide you in terms of the types of questions you might ask a jury pool in order to get, the responses you need to identify who those favorable jurors would be, maybe.
Well, and I think the answer is yes again, because, remember that the data is telling you the effect that it had on different genders, different.
And we're able to break that down,
races. And so that's going to help you, craft the types of questions in jury selection, obviously time permitting and the court allowing you to pick, the most favorable juror. And I'll tell you something else, and this just kind of came to me. There are still some jurisdictions, and particularly in federal courts, that allow zero jury selection. Zero. It's all judge-conducted jury selection. So again, they're supposed to tell the judge, they're supposed to tell the judge the truth, but you've got some guy or some gal in a robe sitting on high, way far away. Most jurors are going to just say, oh, sure, I'd be fair. Sure, I can do this, whatever. My point is, when you're going in totally cold, totally blind, and all you have is maybe a questionnaire and limited to no questioning from the attorney, that data may be the only thing you have to go on.
Yeah, that's the power of having additional and especially very analytical data about the types of responses you get from people that fit into different demographics and different segments of all types, as where the Yale Insights product really gets that granular detail. And that's something that we're always trying to find different ways that technology can be applied. And I appreciate your insights on it. And I think a lot of other attorneys and other people who may be watching this podcast may appreciate them as well. Let me pivot just a little bit and just ask you a few questions about other technology tools that you guys use in your practice. You mentioned that Yale Insights is COVID proof, and certainly we feel that way as well. Um, but how have you had to adopt technology in the past year just to handle COVID beyond having courts closed? I know you mentioned, that in settlement meetings and things like that, now sometimes they're being conducted by Zoom. I mean, how much of that stuff has really changed the way you practice law?
Well, I mean, I'll tell you, it was an adjustment because I mean, I've always been I want to be in the room with the person I'm taking a deposition of. I want to be in the room in a mediation,
Yeah.
because you have to grab someone's attention. I mean, and if you're not there, it becomes much more difficult. So, one of the things that I think is really important in the Zoom age is you really have to be, even more so than usual, prepared ahead of time. You've got to have your exhibits ready. You got to have it flow. You got to have it move. You got to be able to show it. You got to be able to display it. You got to be able to highlight it on the fly. And that goes for, again, not trials per se, because we haven't done Zoom trials, although I've heard some people have tried them or it's been offered, but it haven't been a lot of takers. But when it comes to a mediation, you really, really, really need to have top flight technology. Because, remember now, people are appearing remotely and they have so many distractions. And sometimes, even though they're, duty bound by the court orders to watch, how do you make sure that they do? Or how
Yeah.
do you ensure that you do? So you have to make sure you have phenomenal graphics. I mean, look, we live in a CSI world, and that's nothing new. That's been going on for years. People want CSI. So, we work with a lot of groups, and this is not new for COVID, but, it's been, I think, expanded even more. We do animations. We do animations of a crash. We do animation of an injury, showing how the injury occurred. We do animations of surgery. We colorize films, x-rays, injuries, so that they become real. Sometimes, with technology, things happen with surgeries, and they do surgery, Scott. Some of these complex spine surgeries, they'll do an incision that is the size of a grain of rice. And I'm holding my fingers here and I'm doing it on purpose, a grain of rice.
Yeah.
And sometimes the misconception is, oh, well, this is a outpatient procedure, and it's a tiny little incision. I had a surgeon once say, the only one that calls it a procedure and not a surgery is the one not getting that surgery. So, so my point is this: the animation shows that with that tiny little incision, the massive amounts of complicated surgery that they are doing inside the body, that is just eye-opening. I mean, I've had jurors, even some of the young ones, that aren't impressed by much and got that short attention span, and their jaws are dropping, and so this technology, I think, in fact, I know from my practice and other practices, because it's been a big talk amongst trial lawyers, is getting your graphics great and getting them great on the front end, and not waiting till trial, because again, with COVID, we haven't had trials up until just a little bit now recently.
Yeah. Do you see any of that changing? Let's cut to, a year from now, everybody's vaccinated, or as many people as we can convince to get vaccines, uh, and everybody's sort of back to a normal sense of their everyday life that they might have had pre-COVID. Do you see any of this technological momentum changing? I mean, I feel like it's probably, nothing's going to stop it at this point. I don't know that we go back to a more analog existence or a less remotely connected existence. But I mean, how do you see that going a year from now?
Well, I mean, look, there's not a substitute, Scott, for an in-person jury trial. I
Of
mean,
course, yeah,
and one of the things that people are grappling with now as they're starting trials is, how do we see someone's emotions with a mask on? While we're still wearing masks, and so again, I don't think we're ever going back. I think we've learned that we don't need to do nearly as many things in person. We can do things more efficiently. We can do things much quicker. We can save travel time and get a lot more done. But not just Zoom, how we present things and how we've had to present things is here to stay.
Yeah.
I think that it is definitely, effective and time efficient. That being said, we're human beings. We want interaction. We want to be able to see people. And I think I will tell you, it's been kind of interesting because a lot of the judges now will give you options between the old school conference call phone hearing versus the Zoom hearing. And a lot of the judges are just, Zoom only, because I think they just want to see a human being.
Yeah. Yeah.
Humans. And so I think that sort of tells you that the nice thing about the video interaction is it sort of gives you that hybrid. You're remote, but you're also kind of there too. Just seeing a person's face, being able to connect. Is it the same as being in person? No. But I know that our local judges here have talked about some of the more rudimentary hearings where you've got lawyers that are sitting there in the courtroom. We have these things called pre-trials, where you're basically just checking in before a trial. Hey, everything's still on set, on pace, whatever. 5-minute hearing. Sometimes you're driving 30 minutes an hour, 2 hours, going through parking, paying parking, finding parking, going through security, then waiting an hour, then seeing a judge for 5 minutes. That's not something that requires an in-person hearing. That's a gigantic waste of time. It's a waste of time for the judge. It's a waste of time for the court security, the court staff. That is the kind of thing, and I know our chief judge here in Orange County and here in Orlando has said, we're going to keep those as Zoom hearings, permanently. And it should be. And so I think, the short answer again, although somewhat of a long answer again, I apologize, is I think it's here to stay. We're going to get back to in person, but we're never going back to the way it was. And I think that's a good thing.
Yeah, that's a perfect perspective, and I appreciate that. And I like long answers, by the way. It means you're really thinking. Those kinds of efficiencies, I think, if there's any silver lining, and it's hard to put a silver lining on, a pandemic that unfortunately has cost a lot of lives. But if there's any silver lining at all, I think one thing we've discovered is that there were a lot of inefficiencies we have been able to eliminate with, technology that was already available. And I hope that those things do stick around even after we get past this COVID-19. Yeah, I know that you're a very busy man, Nick, and I want to let you go. I think we've run just a few minutes over your the amount of time you had set aside for us. But I want to throw a couple of items in here just to praise you a little bit, or give a couple of highlights you didn't mention when you were talking to us about your career. In 2009. And I love this because it makes you sound like a comic book hero. In 2009, you were voted a rising star by the Florida Super Lawyers. and I love that. I imagine they would have called it the Justice League if they weren't worried about a copyright infringement. But can you tell me a little bit about that group? Is that a professional association that's in Florida?
Yeah,
real quick.
It's actually a national group, and they are in each state, and those are nominations from fellow attorneys. And so, that was a nice honor. It's nice to get acclaim from your peers. This is an adversarial profession, and so sometimes the best praise you can get is from your peers, and sometimes it's begrudging. Just to be honest. So
yeah.
But yeah, there are a lot of organizations like that. I think that tends to be one of the more legitimate ones. I think like any profession, you're in obviously, TV, radio. So, there's some of them you're just like, oh, you're the, broadcaster of the year of the, Northeastern, Kentucky, former Broadcasters of America Association. It's so, So again,
For the lower counties or something like that. Yeah.
so I think that's one of the more legitimate ones. But yeah, it was nice. It's nice to be recognized by your peers, and they do tend to sort of gear it towards folks from the other side as opposed to just folks in your own law firm.
Well, and how about this? In 2019, named one of the National Trial Lawyers Association Top 100. That's got to be a big one.
Yeah, it was nice. I mean, again, it's. I'll tell you, Scott. I have a passion for what I do, and I tell folks that the highest honor you can get is the knowing that you did right by your client. One of the nice things about representing injured victims, due to the careless acts of others, like I've done for most of my career, is you get to help folks and you really get to make a difference. And so I think the best way to answer that question is I think that shows that, I've done my job, and my job is a passion. And it really gives me a lot of pride and joy knowing that I can help other folks and I can help change their lives. Not everybody may appreciate it. Most folks do. I will tell you, on this side of the fence, you find a lot more folks that are appreciative of what you do. And in the end, you just got to do your job and do it right. And again, it's maybe this isn't the answer you're looking for as you're asking about, achievements, but you can't do this job, or I think really any job, for a pat on the back. The best praise you can get is knowing that you've done what you were supposed to do. And if you've done that, then that's what it's about.
Well, absolutely, of course, and with you, it definitely shows. Um, we appreciate your time, Nick, and we'll go ahead and wrap this up and let you get back to work so that you can continue helping people. But on behalf of Yale Insights and everybody who's watching this, I just want to thank you for joining us and giving us your thoughts.
All right. Well, my pleasure, Scott. It was great. Thanks for inviting me again.
All right. Thanks very much.